Good afternoon, everyone. My name is Rostam Neuwirth. I'm a professor at the Faculty of Law of the University of Macau, and I will talk to you today about legal education in the time of Oxymora, which is really about the role of language in legal education and in law in general. A starting point for me is the observation that law acts mainly through language, written and spoken. Of course, also other ways to communicate, but primarily through language. And in this context, I would like to raise the point that there are specific linguistic concepts like rhetorical devices known as the oxymoron and paradox and others, which I think are increasingly being used today. And especially not just in poetry and literature, where they have been used frequently, but also in scientific discourses and in legal discourses, as well as in daily language. That's why I think they're an important sign of our time and may help us to think about the future of law and legal education. But first, I would like to say that as a general observation also, there is a problem with our language in the sense that it puts us into modern languages in particular, put us into a certain framework of past, present, future, which limit our understanding of the complexity of reality, actually, as it was found here by Carlo Rovelli in his book, The Order of Time. And that is important to consider how we perceive change. And change, constant change as an oxymoron, has been named as one of the fundamental problems of law, namely how it can preserve the integrity over time while to adapt to newly emerging circumstances, which is counter to the goals and expectations of the rule of law in terms of providing us with legal certainty and legal predictability. So I will start with looking at the past briefly. When we go back to 1995, James Rosenau predicted the 21st century to be an age in which we need to discern powerful tensions to deal with profound contradictions and perplexing paradoxes. And paradoxes are really just cousins of oxymora. They all express some contradictions, and contradictions are a challenge to the legal mind, as I will show you later. But first, when we look at the present, we see that the change was rapid in the past decades, years, and it is accelerating. And with it, the complexity increases as well. And we have a very bad example, if you want, the global pandemic of COVID-19 shows how interconnected our reality is already globally. And it is only probably indicating future trends, like with the Internet of Things here in the middle, where the levels of interconnectedness are only going to increase. So what that means is that we have in the past, the UN, for example, framework under the United Nations Charter, we have designed international organizations competent for different areas like health, culture, labor. The World Trade Organization, an important pillar of global governance, the whole economic sector resting on it, was due to an accident never included in this family and is therefore separate as well. But that only shows to what extent we have fragmented international law and the institutions as well. And nowadays, the problem is that this is reflected also in education. Our universities are all fragmented into different faculties, and within law, the law faculty, too, we have these compartments of local, global, public, private law, etc., and even more levels of specialization. Whereas the reality now shows that with an increasing number of important new technologies, new phenomena, new threats, we see that things are actually very, very strongly interconnected and mutually influence each other. And that is a reality that is also reflected, I will show later, in our perception. And I think this hampers a more coherent form of global policy making and a more consistent, the establishment of a more consistent global legal order in the future, which is why legal education is called upon to change something here and look at how changes in language may affect law and legal education. So when we look at the future, I've observed in a book that was published in 2018 an increasing usage of especially oxymora, but also paradoxes. You can easily go to your university's library web catalog and search titles, articles, books, and you will find a lot of these terms, which is striking because an oxymoron is a contradiction in terms, and we expect from science to not give us contradictory answers, but to provide clarity whether something is scientific or unscientific or correct or false. And this is a problem where oxymora come into play. But yet, I believe they indicate a problem, but they also indicate ways to the solution of the problem, and therefore they are really a trend and maybe possibly a language of the future, which then will also spill over to the future of law. So here are a lot of examples. I will show you here a few, notably sustainable development, United Nations, globalization, artificial intelligence. They all have been qualified and defined as oxymoronic because of their inherent contradictions. Alternative facts, also a very important one, because a fact is supposed to have no alternative. It's a fact, it's established, that's it, and there's no alternative. So that's why people said it's an oxymoron, as it is the case with big raw data, the sharing economy, fake news, all concepts that really are of extreme importance today. And here we see that if we follow them and construe them as an oxymoron, we have a problem because of the underlying logic and our language as well. At the same time, I said they may provide also some solution, and I will show that at the end. First, I would like to say how do these concepts change our legal thinking and reasoning? First, they already increase in number. That means they increase also the kind of uncertainty of our understanding. They indicate that things are changing faster because things fluctuate between extremes. So like local and global becomes global, which is faster to describe a process when things are changing and shifting between two opposite levels. And that's why they challenge our dualistic thinking and binary logic. And with that, it makes it more difficult to decide, because if it's not clearly right or wrong or legal or illegal, how do we decide what things are? And that is reflected in I think, a decrease in the ability to reach a consensus, which is the basis for international or lawmaking in general. And with all that, I think, again, they increase the uncertainty and unpredictability generally, and threaten, therefore, the rule of law. And that's why we need to react. So what is the solution here, really? And I've been pondering that problem for a long time, and I can only conclude at the same time that we probably need a kind of change of cognition first, before we can really start to change the law and the international legal framework. And I found some support here that the law changes because the language changes. And when the language changes, the law changes as well. And this all leads to deeper layers of behind language. We say there's grammar, but there's also the mind and as a black box, not just the black box of technology that algorithms determine our life. No, it's also the algorithms that work in our mind that determine our behavior, and with all that create constantly, we're recreating basically constantly our future. And that was also reflected in an article in 2007, confirmed by Professor Lang, that international reform of institutions and so on requires also a cognitive change. And with this global pandemic, I think we have a real game changer in a sense of changing the cognitive game, because we are all basically around the world, and at the same time in real time confronted with this challenge and new reality, I think, which will leave a long lasting trace in our minds. And there's also support in an interest. Metaphors, also rhetorical figures. They are not just for poetry, they are really concrete. They change the way we perceive, they change the way we think, and with that, the way we act. And here we are from theory to practice, and that is exactly what the law as well does, and legal education. We provide for the practice of tomorrow. And that's why I think language and cognitive questions are extremely important to consider in the future of legal education. And then I want to finally mention like the connection between the senses and Oxymora, where Oxymora turned from a problem into maybe the solution. If we take these examples of synesthetic like Oxymora, like sweet melody, cold light, and so on, which was presented in an article here in the late 90s, that they bridge the different senses. Synesthesia is a condition where you sense together. You have a kind of intensification of sensation through the connection between different senses, like seeing, hearing, and so on, which come together and are not in isolation. And I believe that our perception is also fragmented between these senses, and we order these senses also in different, in a hierarchy. For example, the law is said to favor the visual sense, sight, like the concept of evidence comes from Latin to see. So what we see is more important than maybe what we hear and what we smell and other senses. And I think in the future, synesthesia indicates as a condition this ability to better connect them, which is why I drew up a different graph, which should look slightly different like this, where each sense is embedded in the other and not isolated. And we must think also in terms of, for example, legal categories, legal fields like public, private, international law. They are not opposites. They are not isolated. They are connected and they complement each other in many ways, and we need to bring them to a greater consistency and coherence. And this, I think, is the main lesson we can learn from these oxymora and paradoxes for the future in legal education and in drafting of laws as well, and as they will hopefully together with cognitive change lead to a different understanding of a global reality, which we already have before our eyes. So ultimately, I think we already have this proposal for a T-shaped lawyer. The lawyer of the future. Legal education is not only going to educate students in legal skills, but also in a horizontal, like basically bar of different skills, interdisciplinarity, and so on. But I would like to add like kind of a top to this T-shaped lawyer, which makes it and kind of, I call him the oxymoronic lawyer, or I think it's the role of language and logic that needs to be considered, especially because the law, for example, needs to be communicated effectively. This is, there's the principle that nobody can be excused by not knowing the law. So we need to make sure that we can provide the most accurate information in simple but comprehensible terms. And oxymora need therefore to be understood and taught in the future, also in not just in linguistic studies but also in law. So I thank you very much for your attention, and I look forward to your comments. Thank you very much.
Thank you very much indeed for that presentation. And so we've got a few minutes for questions and comments. I think you'll see it's looking for comments as well. And here's one. Here's a question. Should law schools introduce a subject or course on an interdisciplinary approach that draws on legal education, legal practice, language, and applied linguistics?
Thank you very much. I would definitely agree, and I think it is necessary, and it is much more of a practical concern than most people think. I try to show that language has an immediate impact even on our thoughts and ultimately on our behavior. But even in the legal field, there is something like forensic linguistics, and we have, for example, copyright cases, alleged plagiarism, where you really have to identify each word that might have been copied and plagiarized, and make very complex linguistic analysis, and also the same in IP law, trademarks, but also sometimes, I think, I'm not a criminal lawyer, but I found in these books that there can be, there is a case of a suicide note, and a linguist established that it was not written by the victim. So I think, as I said, and as others said, actually, language is one of the primary means through which the law acts, and we should therefore give that, I think, the proper role in legal education as well. So yes, I would definitely agree. Thank you.
Can I pose a question just while we're waiting?
Sure.
Well, I mean, and again, I always feel as though I might be betraying my ignorance or not having understood. But as I understand it, part of what you're saying is there's a kind of a tension between our instinct as lawyers, which is always for certainty, to assign very precise meaning to words, and what you say is a growing everyday recourse to oxymora, which defy that kind of instinct. And if I'm right, if I'm right in understanding that that's part of your message, then trying to think, well, what's the lesson for legal education? I was thinking, well, partly what you're saying is that for legal practice, the implication is that as we try in modern lawyering to find new ways to communicate legal knowledge, we should ignore our lawyers' instincts in the use of language and look for richer, like synesthetic or oxymoronic ways of conveying legal knowledge. Is that part of it?
Yes, exactly. I mean, one thing is that I wouldn't call it instinct. I think it is already due to education in earlier stages before university that, especially in my experience in myself in Europe, was a very strong focus on dualistic thinking and binary logic, which is not, I don't think we're born with that. I think we are mainly educated with that. And nowadays we face a lot of phenomena which are more of a complex and contradictory nature and require fuzzy logic. The fact is that in technology, washing machines, air conditions, they use fuzzy logic because they are more efficient, energy efficient because of that, than using just peaks between heat and cold. So I think it's not that I don't want to throw out the baby with the bathwater and say all this Aristotelian dualistic thinking is useless. It was very useful for the possibly until the Newtonian or until Einstein in that paradigm, but now we need to complement it by new layers and different modes of logic. And I think my former supervisor, Professor Glenn, in one of his last chapters, he quoted one edition of Dicey and Morris where they said the conflict is not in reality, is in the mind of the judge. So I think we can possibly find more creative solutions to a lot of real actual problems when we expand our logical, like the boundaries of our logic beyond merely binary and exclusive logic. So I think, and especially I must say that very often in conversations I have, lawyers who practice are faster in accepting that idea than when I go to conferences and try to present the idea.
There's a question I'm going to put to you in a second from my former colleague Esther Erlings. But before that, I just wonder whether we're going to hear more about what you're saying, kind of the our way of thinking and machine way of thinking. I wonder whether we're going to hear more about that from Richard Susskind in his keynote. But now can I put to a question from Esther Erlings? And Esther says, why is the oxymoronic lawyer a different skill, also in view of the answer to the first question, and not part of the vertical bar legal knowledge and skills?
Well, because it is built in a way on the assumption, as I said, of a future cognitive framework or a mindset. So I think it doesn't fit into, because one of the frequent definitions of paradoxes, in particular from the perspective of neuroscientists, is that they point to some future reality, or they're the language of realities that have not yet come into play in a way. So that's why I don't want to add them to an existing layer, because I think it is a very pro futuro, or like a for the future approach, which is based on a change in a cognitive mindset, which is one question that I cannot easily answer, because I don't know how long it takes for cognitive changes to materialize as such. But I think that very often we see that these changes come very abruptly after some time. So I think we are, but of course in terms of years it is very difficult to predict, but I think it should be added as a on top as a new form of thinking, and it takes probably time to be educated as well. I mean, I have spent years now trying to unlearn or add to my former legal training that I received more than 20 years ago, where everything was right or wrong, or valid and void, and guilty or innocent, but not both at the same time. So I try to exemplify that, but I'm of course open to any to include it anywhere, as long as it's included, I think. Thank you.
One practical thing, I was just thinking, I remember reading a long time ago an article by a solicitor who became a poet, and he thought they went very well together, that it wasn't such a big gap as you might think. And do you think the study of poetry might be, or making people write poetry?
Oh, definitely. I mean, my own grandfather was a judge, and I remember that he used to always treat the drafting of a verdict as also a literary challenge, and law and literature is of course is a recognized. I mean, we just can think of the book. What's his name now? Judge. The paradoxes of legal science. What's his name? Cardozo, sorry, who of course has fully, I think, shown that link, and many others. So definitely there is no contradiction there at all. There's a mutual enrichment, and as far as I remember, I think poiesis means a kind of creation. So law is also supposed to create a kind of science fiction, if you want, or a future reality through the poetic fiction that it puts into its text. So definitely I see only positive synergies here. Thank you for that.
So that's great. Thank you very much for that presentation and for the discussion.